So good afternoon, ladies and gentlemen. My name is Lando. We are privileged to have today to host a webinar on transition in the Kenyan judiciary.
This meeting is being recorded
by Law Africa, and it's the first in a series of webinars that will be tackling several legal issues with the aim of just demystifying law and discussing pertinent legal issues in our environment currently in Kenya and even globally. And so before we hit the road, so to speak, I would first wish to invite the Managing Director of Law Africa, Mr. Martin Wafula, to make a few opening remarks. Thereafter, then I will introduce the panel that we have and introduce the various links that we are available on, and then we will proceed with the webinar. So without much further ado, let me invite Mr. Martin Wafula to make a few opening remarks. Thank you.
Right. Good afternoon, everyone. I want to take this opportunity to welcome all of you to today's webinar. I'll just give a brief history about Law Africa so that you know who the host is. So we are a publishing industry player, sorry. We pride ourselves as a content provider for content in the legal space. We're a subsidiary of Longhorn Africa, which is NSE listed, and it has a presence across East, Central, and West Africa. Some of the leading legal giants actually publish with us. Just to mention, we have content to do with the normal course books for legal profession. Also, we have contents that support NGOs, students, and corporates. So with the onset of COVID, we needed to find out how does the public then get access to information? And we thought webinars would be the best way to do that. And that's why we have organized this to be the first in a series of several. One of my mentors told me that lawyers are paid to speak. Unfortunately, the panel that we have today cannot be paid any amount to speak. The wealth of experience and knowledge that they have is very profound, and I'm sure we are all going to benefit from that. So feel free to give your questions, give your feedback through the channel, and they'll be able to attend to that. Thank you very much. Over to you, Victor.
Okay. Thank you very much, Mr. Wafula, for those introductory remarks. We come a very long way with him. That is a story for another day. Now, we are live on KTN and also on Facebook, in addition to being on this channel. So in terms of interactive engagement with our speakers and with today's webinar, you are invited to send in your questions and comments on the chat function. At some point, we'll be giving you a chance to ask questions. So keep the questions coming in through the webinar chat function on Zoom. Unfortunately, we'll not be able to have a situation where you ask questions live on air for today, but we'll see how in future webinars we can be able to accommodate that in terms of the technological functionality. But for now, we'll just be receiving questions and comments on text, and we will be engaging with our panelists using that medium. Now, as said, we are going to, this session is going to last from now until about 4 p.m. So we thank you for your time, and we urge you to just stay and let us have this robust discussion on matters pertaining to the judiciary. As you are all aware, from 2010, we had the new so-called new constitution that came into play. And one of the hallmarks of that constitution is a robust judiciary. One of the envisaged governance institutions in that constitution and in the current constitution was a robust judiciary. Now, the judiciary has undergone several transitions in terms of its leadership. We had the initial Chief Justice post-2010, the Honorable Willie Mutunga. Subsequently, then he retired, and we have had the tenure of Honorable C.J. Maraga, and currently, most recently, we have Honorable Chief Justice Martha Koome take office and assume leadership of the judiciary. Now, the judiciary has also worked against a certain context and in a certain context. And so that is what then brings us to this discussion, and especially in view of the COVID pandemic that has really affected operations in all sectors, including in the delivery and the dispensation of justice. So that is what we're going to be discussing today. We're going to be discussing issues to do with the structure and the history of the judiciary. We're going to look at the state of the judiciary right now. We're going to be looking at the way judiciary has embraced technology in its operations and the future of litigation and legal services, as it were, moving forward, especially in a digitized environment. And to take us through all these discussions, I have with me a very robust panel of experts to just take us through and give us snippets of their wisdom and knowledge on these elements pertaining to the judiciary in transition in Kenya. And so I'd wish to just call upon the panelists to say a few words. We are joined by Professor P.L.O. Lumumba. He's a lawyer and a Pan-Africanist and a very eminent scholar. Maybe I just wish to invite Professor Lumumba to say a few words to greet our viewers and listeners and those who are joining us on this channel. So over to you, Prof. Just one or two remarks.
Yeah, thank you very much. Let me first thank Law Africa for putting together this webinar, particularly at this time in the history of the judiciary. I think there is merit in engaging in a discussion about the judiciary and to look at its future going forward, particularly in what you call the transition period. So I'm happy that we are going to have this conversation.
Okay, thank you very much, Prof. And joining us also is the first Deputy Chief Justice of the Republic of Kenya post 2010 Constitution. And we are joined by Honorable Lady Justice retired Dr. Nancy Baraza. She is a senior lecturer and the chairperson of the Public Law Department at the University of Nairobi. Please, Honorable Lady Justice, please just greet those who are joining us also.
Thank you very much, Dr. Lando, and good afternoon, everybody. I think I want to join my colleague, Professor Lumumba, in thanking Law Africa for arranging these webinars. I think they are important, and more so regarding the judiciary, which we must keep tracking to see the progress, and because the judiciary is very, very important, and more so within this transition period. So I'm happy to be here with you. Thank you very much.
Thank you. We are also joined by Steve Ogola. Steve Ogola is an advocate of the High Court. He is the managing partner of Saroni and Stevens Advocates. And so let me just invite him to also say hello to those who are joining us on the platform. Karibu Wakili. Wakili, we are having a challenge getting you on audio. Maybe we'll... Are you able to get us?
Yes. This is just to express my appreciation to Law Africa for organizing this webinar, and to quote Professor Pilo Lumumba, who always says that if you do not agonize, you cannot organize. So we have to begin to reflect on the changes you've seen in the judiciary, what it means for us, and what we can do to improve access to justice, which is what this webinar is all about, in my understanding. So thank you.
Okay, thank you very much, our panel of experts and who will be taking us through this webinar. We are joined by quite a number of people. I can see Simon Wekesa is watching from Baragoi, and we have quite a number of other viewers who are joining us both online, on Zoom, on Facebook, and on KTN News channel. So thank you very much also KTN for having time to also host this webinar. And to just start us in our discussion, Professor Lumumba, Kenya's constitution, the one that we are engaging with currently, it gave us a promise of a judiciary that is robust, a judiciary that is engaged in providing services to the people, that checks on the excesses of the other arms of government. We envisage a country that is democratic, that lives up to the ideals set out in the Constitution. So just briefly, from your evaluation and in your view, that 10 years on, 10, 11 years on, do you think that the current formulation of our judiciary has met the expectations that have been outlined in the Constitution? And this is also against the backdrop that, of course, you were greatly involved in the process that led up to the framing of the 2010 Constitution and the conclusion of the Constitution. So from where you sit, do you think that the judiciary as currently configured and with the experience 10 years on, that it has lived up to the expectations that, that are set in the Constitution?
Thank you very much. First of all, it's important, as you've said, to remember the history of the judiciary. Dr. Baraza will remember in the year 2002, when we were collecting the views of the people of Kenya regarding the various arms of government, the executive, the legislature, and the judiciary. We received very clear representations about the state of the judiciary as it then was. One of which was that the judiciary was beholden to the executive, and that therefore in restructuring the judiciary, it was necessary that that nexus of control be reduced or completely eliminated. And that is why, therefore, you see in the new constitution an attempt to remove the executive, namely the president, from direct appointment of judicial officers in the upper echelon. You'll also remember that during that period, we invited a panel of experts constituted from the Commonwealth, led by Professor George Kanya-Ihamba. And it was an indictment of the judiciary as it then was. And ultimately, of course, on the 27th day of August 2010, we ended up with the Constitution, which is very clear on the modalities of the appointment of judges and magistrates. And what you'll see is a clear attempt, particularly at the level of the upper judiciary, to mean the Supreme Court, the attempt to ensure that the president plays a very minimal role. And that is why the composition of the Judicial Service Commission is very important in this regard. The president is represented, and therefore, if there is anything that he or she, the president, desires to say a particular nominee of the judiciary, has that opportunity at the Judicial Service Commission. But your question directly is, what is my assessment of the judiciary as it is now? There are areas where I think the judiciary has done pretty well. I've seen even in the lower magistracy to mean the lower judiciary to mean the magistrates across the country. One sees an enthusiastic group of people who are trying to ensure that the dispensation of justice is done in accordance with the law. In the High Court, I've seen some beautiful judgments that are being written by some judicial officers. I think the decision to create specialized units of the court, the employment court, the environment has also been good, although I think there is a problem there. I personally hold the view that a judge should be appointed as a judge of the High Court and that the divisions should be created by dint of administration. And of course, in the Court of Appeal, the judgments are quite sound, but there is a problem there. You discover that because of what must be lack of coordination, one bench of judges of the Court of Appeal sitting in Nakuru may say something totally different from another bench in Nairobi. And that is creating a lot of problems for those who are in practice and are therefore advising clients. The Supreme Court, of course, has been judged on the basis of what it has said in presidential petitions, which come after 5 years. And I think that is pretty unfair, particularly because whenever a decision is given by the Supreme Court, and it has been on 3 occasions, they are then judged by the political class. And the political class in Kenya makes a lot of noise. And they think that judicial officers should do their bidding. And when they don't get judgments in their favor, then they degenerate into insults, which is completely unnecessary and unfair. But overall, I think that the judiciary is trying, the jury is still out. A lot of things can and should be done. And I believe at a later stage, we are going to talk about the whole idea of digitization across the country. Perhaps sometimes we also judge things on the basis of what is happening in Nairobi, but what is happening in Migori, what is happening in Kubu or in Chuka or in Machakos may not be what is happening in Nairobi. Overall, on a scale of 1 to 10, 6.
Okay, thank you very much, Prof, for those incisive initial remarks. And I also wish to pose the same question to Honorable Lady Justice Retired Nancy Baraza. You were the first Deputy Chief Justice under the 2010 Constitution, and I am sure that as part of the team, you had this vision for the judiciary. And sitting back and looking at where we are 10, 11 years down the line, and also in view of what Professor Lumumba has mentioned, what would you feel that still needs to be done? What is, in your view, the state of the judiciary, so to speak, and not only from the superior courts, but also going down to the magistracy as well?
Thank you very much. I think I want to echo what Professor Lumumba has said about the state of the judiciary before 2010. It was a very, very subservient arm of government, of course, captured, or in the eyes of Kenyans, it had been captured by the executive. And when we collected views from Kenyans, one of the institutions that they wanted reformed, and reformed very, very hard, was the institution of the judiciary. And of course, its subservience had impacted on delivery of justice. It lacked resources. Infrastructure-wise, it was deprived. And the whole issue of delivery of justice was a problem. And of course, that is how we created that very, very strong, those strong provisions for the judiciary. Kenyans wanted a very independent and robust judiciary, as you have said. And just to echo what Professor Lumumba has said, that independence had to do everything with appointment of judges, and that is why the Constitution creates an independent Judicial Service Commission, which has the overall power of appointing judges. And therefore, what is happening now, like the executive wanting to overreach itself and have a say in the appointment of judges, I think will come as a disappointment to the majority of Kenyans. So that is what they anticipated. Then coming in as the first Deputy Chief Justice under the new constitution, I came in as Dr. Willie Mutunga's deputy. We found a very, very weak institution. And I remember my boss then, Professor Dr. Willie Mutunga, observing when we had served 100 days that this is an institution which had been set up to fail. It was very weak. It was deprived of finances. And I think the biggest budget that had ever been allocated to the judiciary was 3 billion. That was the biggest budget. It couldn't do much with that. We had shortage of personnel, shortage of judges. I think we had 40 judges for a population of 40 million. Really, if we expected them to deliver justice, that was too ambitious on our part. So we found a very weak institution, deprived of finances, deprived of independence. It had no internal institutions for accountability, no meaningful policies to make an institution run well. We found a place where, for example, a transfer of judges was very, very haphazard, allocation of resources internally, things like cars, very, very haphazard. So we started more or less from scratch, and I'm pleased I got the opportunity of being party to the creation of what we call the Judiciary Transformation Framework, which is available. People have read it, they're writing about it, and in it, we had a vision of how we were going to structure the judiciary, what mechanisms we needed to make it robust, and I think from then on, various aspects of transformation have taken place within that framework. Things like infrastructure, things like increase of finances, things like and policies, to make the institution run. And Willie Mutunga, former Chief Justice, carried his reforms within that framework. And then come Justice Maraga, 2017, or is it 2016? He also had what he called what did he call it? But it was a build-up on the initial judiciary transformation framework. And they have done well in several areas. I would think in terms of infrastructure, they have built courts around the country. They have court users committees all over the country. Where they have not physically built courts, they have had mobile courts in remote places. But I think they have suffered quite a bit in terms of finances. As you all know, I think they haven't been getting a lot of money from the government, and that has hampered the transformation that they could have carried out. But overall, in terms of infrastructure, I think they have reformed quite a bit. And of course, we do know that more judges were appointed, and delivery of justice has become easier, although still there are problems. In terms of jurisprudence, the High Court has been very, very robust in terms of interpretation of the Bill of Rights. And that was a concern for Kenyans. We came from a place where rights were almost unknown and almost despised by the judiciary itself. So I think quite a bit has been done. We see strength in the High Court, in the Court of Appeal. Many scholars say probably it hasn't been as robust. You come to the Supreme Court, then of course people see it as a political court. But I think we have moved, although there are many things to be done. Finances have to be availed, and the judiciary fund, which we envisage, or the Constitution envisages to be independent, to draw its money directly from the exchequer, that would give the judiciary financial independence that it requires. But so far, I think there has been movement in the right direction, and overall, I would give them 6.5%. 6.5 over 10, not percent, over 10.
Okay. Thank you very much, Mwalimu, for your comments. I can see we are now we're in the company of my teachers and scholars, and they are awarding marks. Over to Steve Ogola. Steve Ogola, from a practitioner's perspective, and really looking at the comments by Professor Lumumba and also the comments by Honorable Lady Justice Retired Dr. Nancy Baraza, that have the reforms that were initiated then, have they translated into something beneficial for advocates in practice, so that practice in 2010 vis-a-vis practice in 2021, have we seen an improvement in the way that the judiciary engages with litigants, it engages with the bar? From a practitioner's perspective, I'd also just wish to post the same question to you. What is your assessment of the current status of the judiciary? Then we'll now go into the whole issue of the digitization conversation as we proceed. We'll also later on go into the thorny issue of the appointment of judges and the 6 who were not appointed. We'll go into those conversations later on towards the end of our webinar. We'll also touch on the question of who stands up for the judiciary, because of late we've seen the judiciary make quite a number of bold decisions and bold declarations against the executive. And so we'll also be tackling the question of who will stand for the judiciary in view of its precarious situation as things work. But going back to the question, Steve Ogola Wakili, what is your view from a practitioner's perspective of the dispute resolution lawyering in the 21st century vis-a-vis the status of our judiciary currently? You have the floor, Tafadhali.
Thank you so much. First of all, permit me to adopt and reiterate the comments made by Professor Pielo Lumumba and Dr. Nancy Baraza. I fully associate myself with those views. What I'd like to say is that all of us are aware that because of the robust legal infrastructure that we have in place, at the foundation of which is now anchored in the Constitution of Kenya 2010, the battle for reform and renewal of our institution is partly won. Partly because you cannot reform and renew unless you have the supporting law. So we have the legislative and constitutional infrastructure that is necessary to move us the next level. The next level where we are now, and that is, I think, the battle for animation of independence of the judiciary. It is an ongoing project, and I agree with Professor Pielo Lumumba and even Dr. Nancy Baraza when they say that the judiciary has done well so far in terms of animating its independence. But remember, independence is at 2 levels. There is the institutional independence, and then there is the personal or individual independence. The institutional independence is what the Constitution has assured our judiciary and our judges insofar as the performance of their functions, judicial functions, is concerned. Personal independence, I think that is an ongoing debate because that can only be achieved at an individual level. Can we say with certainty and evidence that the judges and magistrates that we have in place are liberated and do not have to look over their shoulders when they're rendering their opinions and judicial pronouncement? I think that we have to evaluate from case by case, and so far I would say yes. The second issue that is notable is, although the Constitution has assured the judiciary of its independence, and you have seen that the previous Chief Justices under the new Constitutional dispensation, see the founding Chief Justice under the new Constitution, Chief Justice Dr. Willie Mutunga and Chief Justice David Maraga, have done a lot of good job in terms of preserving and protecting the independence of the judiciary. You can see what you may consider as some historical hangover from the executive trying to relieve its influence over the judiciary in post-2010 dispensation. If you want to limit the independence of the judiciary, you don't necessarily need to amend the law to weaken the judiciary. You can delegitimize the judiciary by branding them as activist judges. You can defund the judiciary, and then you can defang it. So the shortest way to kill the independence of the judiciary or to undermine the independence of the judiciary is not necessarily to amend the Constitution as to remove the security of tenure, but to delegitimize it, defund it, and then you can defang it. But I think the judiciary has done a good job in terms of staying the course and animating their independence and fighting for that space. I do not think, in terms of courtesy and committee between offices, that it was necessarily a wise decision, for instance, of the Chief Justice Emeritus now, David Maraga, step on this, as come out in on the steps of the Supreme Court and complain publicly about the deterioration of the relationship between his office and that of the president. But I also understand where he comes from, because he said he had no choice. The president of the republic had left him with no choice, and therefore, if he did not speak, there was going to be a narrative there that was going to be shaped, and when a lie is repeated, it could develop some color of truth. We hope that with the arrival of Chief Justice, Lady Justice Martha Koome, the relationship between the executive and the judiciary will improve. So yes, we are making progress, although not at the pace we had anticipated. Insofar as digital transition is concerned, which is what you asked me to comment on most substantively, from a practitioner's perspective, we must say that it's a welcome relief. It's a welcome relief because lawyers and litigants willing now hoping to initiate court action do not have to travel to Nairobi or to the registries physically to file cases. You can do so within the comfort of your home, but there are challenges that come with the digital transition in the judiciary that makes it difficult for lawyers to effectively harness the potential that exists. I think we'll have an opportunity to look at some of those challenges and propose solutions, what the judiciary can do. But in the overall, it is a good thing that now we have seen the digital transition, and the idea is not to roll it back or to remove it altogether, but the idea is to appreciate the benefits and the challenges and what we can do to improve it going forward.
Okay, thank you very much. Thank you very much indeed for those comments and your views on that. Now, just to our viewers and those who are joining us online and on KTN News, KTN Live, KTN News channel, sorry, and those who are joining us on Facebook, feel free to send your comments. Feel free to send your questions to our panelists on the chat function so that they can also have a chance to respond to the queries from those who are with us. Now, you have set the stage and discussed the question of the appointment of the new Chief Justice and the appointment of the several other judges who had been nominated in 2019. And I'd wish to just take this question to Professor Lumumba. With a new Chief Justice in place, and in view of what the other panelists have mentioned, and with the current context that we have set, what would be your expectations of our current Chief Justice, Honorable Martha Koome, in ensuring that the judiciary, moves forward and ensuring that the questions of independence are dealt with, the questions of funding are dealt with, and the challenges that have been mentioned as afflicting the judiciary, that all those are dealt with. So what would be your expectations of our current Chief Justice in handling the emergent issues that have been discussed so far, plus what you have already also observed from your own engagement?
Let me start by saying that some of the problems that I hear being spoken about or being written about are figments of the minds of the Kenyan press and Kenyan politicians. The judiciary as an arm of government is established under the Constitution, and there are quite a number of safeguards which are deliberately designed to ensure that the judiciary enjoys institutional independence. One of the things, of course, that I think ought to happen going forward is to make the monies due to the judiciary a direct charge on the consolidated fund, so that they are not susceptible to the blackmail of the political class in the judiciary or the legislature. The second thing, of course, is the issue of the role of the Chief Justice. I've had a lot of people saying many things, that Martha Koome, who is somebody I know pretty well and who has been a judge and a practitioner, that simply because she is a woman, therefore things change. I've been in practice for 35 years, and to me, it matters not the gender of a judicial officer. What I want is dispensation of justice in accordance with the law. And the question of building the judiciary is work in progress. As both Dr. Baraza and Stephen Ogola have said, we came from a history where the chief executive, namely the president, thought that judges were beholden to him. And during the tenure of Dr. Mutunga and that of Maraga, there was always an attempt to reclaim that lost territory. But it became very obvious to the president and other political players that that territory cannot be taken away because it is protected under the Constitution. What therefore I expect to happen is for the Chief Justice, as has been said, the Chief Justice of any country speaks through his or her judgment. That is what the judicial officers ought to do. A judge is not judged by many political rallies he or she attends or many funerals he or she attends. I want to see the jurisprudence that is going to come out of the Chief Justice as she joins members of the Supreme Court. Then we'll be able to say of her that this was a person whose jurisprudence was solid, and that when she was confronted with legal issues on the basis of the law, she applied her mind without fear or favor. As an administrator, our role is also that much delimited because we have a chief administrator of the judiciary, and in the Court of Appeal, we also have a president, and of course in the High Court, we have a presiding judge. All these are useful, and as the leader, what one expects is for her to create an environment where decisional independence will be exercised and to engage to the extent that is necessary other arms of government, to the extent that it is necessary. What one must not see is the Chief Justice who kowtows to the presidency or to the political class. So a certain level of aloofness is expected of the Chief Justice.
Thank you very much for that. That the Chief Justice should speak through her jurisprudence, and that is a very wise statement. It's very interesting to note that most people would want to see the Chief Justice engaging in politics, but as judicial officers, they speak through the decisions that they hand down, through the jurisprudence that they create, and as also Honorable Lady Justice retired Nancy Baraza also mentioned that a judiciary is also, judged by the kind of jurisprudence that emanates from it. And so just also going to Honorable retired Lady Justice Nancy Baraza, I'll kind of pose the same question to you with regards to your expectations of the new Chief Justice. She's still new. She until 6 months, then she won't be new anymore. But for your expectations of our new Chief Justice, and also to just make a few comments on that, but also to speak to the question of judicial independence, the question of who will stand for the judiciary. We have seen that there is a lot of backlash from the political class, from the executive, from the political class. And it is within the public domain, the conversation that was happening during the Madaraka Day celebrations. There was a lot of backlash against the judiciary. And you've also seen that the judiciary, the BBI judgment, so to speak, and the fallout and backlash that has come out of that. And so the question is, in view of what Professor Lumumba has said, and also just giving your views on what is on our new Chief Justice's entry, and then you could also speak to the question of who will stand up for the judiciary, given the amount of backlash it is receiving. Over to you, Dr.
Thank you very much. Again, echoing Professor Lumumba, I think we expect a Chief Justice who is going to protect the independence of the judiciary. That independence was not given on a free plate. Kenyans fought for it. And we expect that she's going to uphold the independence of the judiciary, that she's going to ensure that judges have their individual independence. And that much, I'm sure, the Lady Justice, Chief Justice Martha Koome, from her history, I think she's not going to let Kenyans down. She respects the rule of law. Her history says quite a lot about that. But as lawyers and as a country, we expect nothing less from her. Her gender notwithstanding, and she hasn't gotten that job because she's a woman. And therefore, the standards by which she's going to be judged is not on gender at all. So we expect that she's going to deliver as a CJ of the Republic. I think there are many things that are there that are of concern to Kenyans. I think castigation of judges, that is extremely unfortunate. I think the other arms of government must learn to respect the independence of the judiciary, and they ought to realize that there is the appellate process. If you are unhappy with the judgment of the High Court, for example, the Magistrate Court, there is the appellate process which enables you to appeal to the next court until you reach the Supreme Court. And therefore, what we are witnessing, and more so from the highest levels of power, is unfortunate. They need to utilize the appellate process and leave the judges to do their work. So if you wanted me to comment about what we saw in Madaraka Day, extremely unfortunate, and coming from the chief executive of the country, I think it was very, very unfortunate. But we do hope that the advisors of the president, and we hope they are lawyers of sound standing, can advise him on his limits within the Constitution. And that way, then I think we are going to see an independent judiciary whose judgments are respected, and if we are not happy with those judgments, we utilize the appellate process and appeal. Regarding what we should see the CJ do, I will agree with Professor Lumumba that her territory is very much demarcated by the Constitution. She doesn't have to go out of her way to win anything or to win anybody. She just needs to exercise her powers within the confines of the Constitution. And so she shouldn't be bullied around. Probably they are thinking she's a woman, she can be bullied. They can call her to sweet talk her. No, 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 no. Her powers and her duty is defined in the Constitution. And that's what we expect to see. Let us not get the impression, perceived or real, that she's being submerged or made subservient to other arms of government, because then that means she's going outside the mandate that the Constitution so clearly gives her. So we expect robust further transformation by the Chief Justice. We expect quicker and better delivery of justice. And I know her as a practical person. If we get the digitalization going, we get virtual hearings seamlessly done, then I think we shall improve on judiciary, on delivery of justice for the ordinary Kenyans. Thank you.
Sawa. Thank you so much. And we're having a comment from also Honorable Mary Angawa. She mentions that for a successful judiciary, a Chief Justice of Tanzania once said that there must be financial independence, juridical independence, administrative independence, and I would agree with this. There must be the will of the other arms of government. And so I think the clarion call that is being made today is that we need to reaffirm and we need to protect the independence of the judiciary, both financial independence, decisional independence, and all that comes with the notion of judicial independence. Thank you very much, those who are with us, joining us online and on the other platforms. We are receiving quite a number of questions.